And welcome to In Your Corner. John Scholes, Sivan, Tumarkin, 1-855-821-5900 anytime, or help at inyourcorner.ca to reach out through email. We'll get to one of those very shortly. Coming up on the show today, 3 facts you may not know about your long-term disability claim. Stick around for that. But first, once in a while we like to just reiterate what we're doing on the show and why we do it, right?
Yeah, absolutely, John. It's very important that we explain to people, especially new viewers, what it is that we do here. We are lawyers. You're not, but I am.
No.
James is when he comes on the show. We deal with insurance companies, and specifically with long-term disability insurance companies. And we help people who have been wrongfully denied their claims and who have been told that their payments are going to get cut off. And these are unjust circumstances, and so what we do is we take the fight to the insurance company and we explain to people how they can fight back, how they can stand up for their rights, and what their rights in fact are under the law. And we do this day in and day out with people calling us, and we help them, and we have just a tremendous amount of success assisting people against insurance companies.
Speaking of success, we always start with the week that was, or a success story, something that's been happening for you as far as what's going on at the firm. What do you got today?
Let me tell you about a tragic situation. A lady, 36 years old, a cancer survivor, who had, in addition to her cancer years back, she had a car accident, a very bad car accident 3 years ago. And in any event, she goes on long-term disability. And at some point, about 2 years later, she gets an offer from her insurance company to settle her long-term disability claim. Mm-hmm. Now, her LTD policy, like the vast majority of policies, take you up to age 65. So assuming that you meet the test, assuming that you can't work because of your disability in any occupation, then technically you should be getting your payments until whatever age is prescribed under the policy. And in most policies, it's age 65. She's 36 years old. What does the insurance company do? They offer her the equivalent of about 6 or 7 years worth of LTD. And she does the right thing. She gets legal advice, not from me, someone else, but she gets legal advice, and she's told, no, that is a fraction of what they would have to pay you. So of course they want to pay you that money because they want you to just go away.
Get you off the books, man.
Yeah, absolutely, 100%. And she says no. And then they cut her off a few months later, and they tell her that you no longer have sufficient medical proof or documentation to meet the criteria for getting LTD going forward, which of course, if you think about it, is really nonsensical, makes no sense.
You were going to offer me 7 years of coverage, but now I don't qualify.
Thank you very much, John, exactly. But insurance companies often do things that make no sense because they think that they have all the power. And the unfortunate thing is that the majority of people out there do believe that. Mm-hmm. They believe that insurance companies have all the power. Nothing is further than the truth. And of course, I explained to her what her legal options are. I explained to her it wouldn't cost her a thing for us to take the fight to the insurance company to force them to come back to the table and either reinstate her and put her back on claim so that she gets payments month to month to month, or to come to some kind of a resolution. None of that 7-year nonsense, okay? If she's in fact permanently disabled, they should be paying a hell of a lot more than they were offering. And I'm telling you right now, John, they're going to do it. They're going to do it for a very simple reason, because once we start that legal path, once we take the fight to them, we take the power out of their hands, and we force them to acknowledge that there is a risk that they can end up in court in front of a judge. Trust me, they're going to come to the table. They're going to want to resolve it one way or another.
In your experience, what would be their preferred play in this regard? Would they prefer what we'll call it a lump sum in this regard for something more than 7, say 10, 15 years, whatever that would be? Or would they prefer just to put her on claim and let her ride it out slowly until she's 65?
Every case is different.
Right.
I can tell you that I had a case a few years back with a gentleman with severe back injuries. And again, he was told, you're owed nothing. He was in his 40s, debilitating injuries. And they said, no, you just don't meet the criteria, which I thought to myself was insane. And so we started the legal claim. Within 2 weeks of us starting the legal claim, I get a call from his lawyer in a different province. Sorry, not his lawyer, the insurance company's lawyer. I think he was calling from Nova Scotia, because insurance companies can get lawyers from anywhere in Canada.
Sure.
Anyways, he's calling me, and he says, Sivan, I reviewed the entire file. Here's the offer my client is prepared to present. Either we put him back on claim and pay retroactively what he's owed from the time we cut him off, or we're offering, and I can't tell you what the amount was because my client ended up taking that and there's a confidentiality clause. So in that instance, they actually gave my client a choice, and I presented that choice to my client. In some instances, they would rather you take a lump sum because they know that in this lady's case, for example, let's say they pay 15 years worth of benefits. But that's 15 years. That's a hell of a lot less than paying her until age 65. But she may not want to take that. So again, our job is to maximize what we get for our clients. It's to press the insurance company to force them to come to the table, and again, to use every tool in the legal arsenal that we are capable of utilizing for our client's advantage. And as James puts it, and I love that, we don't even the playing field. We tilt it in your favor because we've been there. We've worked for these insurance companies in the past. We know their weaknesses, and we know how to make sure that they pay you exactly what they owe you.
Reaching out anytime is 1-855-821-5900, help@inyourcorner.ca. Mention the emails coming up. We'll get to our first one, this one from Gwen. Gwen writes in, says, my son had a breakdown at work last year because of bullying by his superiors. He's always been predisposed to depression and anxiety, but his work situation, especially last year, really triggered something much broader. His psychiatrist sees him as an outpatient at the local hospital, and my son now lives with me. Despite this, the insurance company insists that it's a work-related issue only, and they've denied him long-term disability. No shock there. Are they right?
No, they're not right, but this is something that happens quite often, and I think that people need to understand the different aspects that we're dealing with here. In many instances, when people contact us for anxiety, depression, a lot of times these are generated through circumstances at work. And you know, from working with Lior, doing the employment law show, that could mean constructive dismissal. There could be a claim against the employer. And so what insurance companies do is they say, well, hold on for a second. We do not insure you against a bad work environment.
Okay.
If you want to take action against your employer, you can do that. But what's happening in this case, in this email you just read, is you're talking about a situation which I see often where the work environment creates the condition, but then the condition morphs into something a lot larger. So now the individual can no longer work in any type of an environment, not just where this poisonous work environment occurred, but in any environment. As soon as that happened, as soon as now, you can't take that person and put that person in any other environment.
Well, this guy's practically a shut-in. I mean, he's moved by, you know.
Then the insurance company's on the hook.
Yeah.
The insurance company cannot now simply deflect and say this is an employment issue. It's beyond an employment. There may be an employment component, which is why, you know, this is why people contact us, because we do both employment law and disability law, so we can advise them on both. But as soon as that condition from that poisonous work environment is something larger than just that employment issue, right? As soon as that person is a shut-in, as you say, they can't work anywhere, now the insurance company is obligated to treat that person as fully disabled under the policy.
And you've mentioned before in situations like this, when it comes to this long-term disability insurer, it may not be different from any other insurer in the fact that because this doesn't show up on an x-ray, it's not a broken bone or a laceration or a concussion, sometimes they don't think it's legitimate and they don't think it's worthy of putting this guy on policy.
Not sometimes, in many instances. And part of it is a predisposition, I think, that insurance companies and adjusters and individuals as a whole in society have not yet accepted the fact that a mental health issue can be as disabling, if not more.
And tougher to diagnose.
Tougher to diagnose and to treat. Right? If you have an ankle sprain, we know what to do. We know what physio we need, a cast, whatever it is. When you're dealing with emotional, psychiatric, and psychological types of issues, it's a different ballgame altogether. And you know, I'm telling you right now, John, there are psychologists out there who are just nodding their heads and saying, I wish insurance companies would listen, because they don't. But again, this is where we come in and we force them to listen. And so, yes, you're absolutely right. It's very difficult to diagnose. It's like an invisible type of an illness or an invisible type of a disability, but there are ways to prove it. And one of the ways to prove it is to show that the individual is getting proper treatment, continuous treatment, and that the people treating the individual are writing through the insurance company explaining why it is that this person is functionally unable to go back to work because of their mental health disability. 3
facts you may not know about your LTD claim. That is on the way as we take a short break here. 1-855-821-5900 and help@inyourcorner.ca. Lots more on the way. Stick around. This is In Your Corner. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca. Hey, welcome back to In Your Corner. Want to reach out anytime, even when we're not here on the show. 1-855-821-5900. Help at inyourcorner.ca is the email address. As mentioned before, we went to break. 3 facts you may not know about your long-term disability claim. Number 1, my brother, long-term disability claim appeals almost, being generous with that word, almost never work.
Yeah, and I want to make sure that people understand that's anecdotal. I don't have statistics. I wish we could get statistics from insurance
start
companies.
Keeping your own.
I've tried to get statistics, and I can tell you I couldn't get statistics, and I wonder why I couldn't get those statistics. In my experience, these appeals, so what is an appeal? Let's just break this down, okay? You've been denied long-term disability, or you've been told your disability payments are going to get cut off. No. Whatever correspondence you get that informs you of that, other than by phone, let's say it's an email or more generally a letter that you get in the mail, that letter is going to have some paragraph towards the bottom of the letter, 2 or 3 or 4 page letter, that will say, you are invited to appeal and you have 30 days to appeal or whatever the deadline, arbitrary deadline that they give you. And what happens when you do that? Well, first of all, these appeals are internal processes, okay? So imagine if you told your child you can't have this candy, but you can appeal that decision. Yeah. Your child comes to you 5 minutes later, can I have that candy? No, you can't have that candy.
But you can appeal.
But you can appeal. It's exactly the same situation. Now, in some rare circumstances, I have seen them work.
Right.
In the vast majority of circumstances, I have seen them frustrate individuals and families, make people angry, make people upset, and in some instances, I have seen people appeal and appeal and appeal such that the 2-year limitation period for starting a legal claim expires. And that is catastrophic, because imagine if the insurance company denies a legitimate claim, and imagine if that claim is potentially worth $300,000, money that's owed to you and your family, and you've ran out the clock because you thought these appeals are going to work. Well, now you've extinguished your ability to actually force the insurance company through legal means to get that money. Insurance company literally, after that 2-year mark, can just not even respond to you. Or frankly, they can laugh in your face. They can do whatever they want because you can't do anything. So these appeals almost never work. There's no pressure mechanism that is applied. There's no pressure that's applied to the insurance company through these appeals. They are internal processes, just like your 5-year-old asking you for candy repeatedly, time and time again. So the alternative is to start a legal claim, which is what we do. Once we do that, we literally start a claim with the courts. It doesn't mean you're going to go to court, but we're starting a legal process. It's a legal mechanism. At that point, we take the power away from the insurance companies. As soon as the insurance companies hit with that claim, they have to assign a lawyer that they have to pay for. They have no choice. Yeah. And then they start bleeding money. And then they think to themselves, aha, this person called my bluff. Now we have to sit down and negotiate with that person or with their lawyer. So that's how you deal with insurance companies cutting you off or denying your LTD. You do not appeal. You give us a call, you let us explain to you your rights, and if you like what you hear, you decide if you want to proceed, and if you do, and it will only tell you to proceed if we think you have a case. I want to make that clear. We don't take every case on. We only take select types of cases, select amounts of cases. Our reputation is important to us. I used to work for insurance companies. James, who comes with me on the show here, also used to work for insurance companies. Insurance companies know which lawyers and which law firms take on every case and which lawyers only take on legitimate cases. And that's our reputation, and that's what we want to keep.
The thing about appeals is scary because people just keep going through it and through it and through it and through it.
They do. They do. But they do that, John, because that's what they're told. Yeah. They're told through those letters.
Well, you've showed me law firms, no names mentioned, that actually says, we will help you go through your appeal. Well, no.
We've had situations because of the show, people getting informed, which is again the main thing here. I want people to understand we're giving you this information. This information is free. Make sure that you just listen to us. Don't just Google the stuff the way you don't Google an illness and get everything under the sun. I have seen situations where people have been told by their lawyers, not only will we appeal this for you, but it's going to cost you $5,000, $10,000,
Nice.
whatever it is. And then they go through that, they pay all that money and for nothing. And then they contact us and they wouldn't have had to pay a cent until the case is over and until we get money for them. So if a lawyer tells you, we're going to charge you for this appeal, you have to really scratch your head after what I'm telling you and make sure that you do your homework and make sure that you don't just speak with us, but speak to whoever you want, but don't just take whatever that lawyer says at face value.
We're talking about the 3 facts you may not know about your LTD claim. Number 2 is this: insurance/sponsored recommended rehab programs can be a win-win for the insurer.
That's right. So this is, again, something that I want to touch on. Insurance companies will often tell you, go to this rehab facility, go to this doctor for treatments. Listen, maybe that facility and maybe that doctor are fantastic.
Sure.
Maybe they are. I am just questioning, maybe because I'm just skeptical and I used to work for insurance companies, I am questioning why the insurance company is telling you to go to someone specific.
What
are they getting from it?
Yeah.
Exactly.
Yeah.
I think, and what I have seen happen in some instances, and frankly too many instances, is I've seen people going to these doctors and not feeling comfortable with those doctors or facilities. And then down the road, I see those facilities or those treatment providers write reports which my clients, people who end up retaining us, are saying, but this is completely untrue. And those individuals are writing reports that are favorable to the insurance company. They're saying this person is now that much better. They're able to go back to work when the reality is that they're not. So I'm very skeptical of the treatment providers and rehab facilities that insurance companies send you to. The solution, as far as I'm concerned, go to whoever you trust. If you trust your family doctor, ask your family doctor for a recommendation of where to go. Maybe you have a chiropractor that you've been going to. Maybe that chiropractor knows massage therapists or, I don't know, osteopaths, whoever it is that you need. Just make sure that you don't take whatever the insurance company, like I said, at face value, because they always have an agenda, and that agenda is to make money, and it's to make money off of your back.
So they can't demand that you go to said physio clinic or whatever. People think that, okay, well, they said I have to go here, so I got to go see this guy.
Listen, John, they can demand that you wear a blue shirt every day if the policy says that you have to wear a blue shirt every day.
Right.
Remember, everything the insurance company tells you to do and demands of you must be grounded in the policy. And if you are questioning whether or not what the insurance company is asking you to do is legit or not, ask the adjuster directly. Show me where in my LTD policy there is a provision that states X. You're asking me to do X, show me where it says X. If it doesn't say that, you don't have an obligation to do it. And you will see adjusters will backtrack and they'll say, oh, no, we ask everybody to do it. No. Your relationship with the insurance company is governed by a contract. It's a contractual relationship, and that contract is the policy. So the insurance company is bound by it, and you are bound by it. So again, to answer your question, you only have to do what the policy says you have to do, no more, no less.
You want to reach out anytime, by the way, 1-855-821-5900, help at inyourcorner.ca. The 3 facts you may not know about your LTD claim. Number 3 is this: LTD insurers are generally skeptical of mental health and psychiatric disabilities. We talked about this.
We talked about this, and it really, really bothers me. And it bothers me because I have personally seen people that I care about go through some very difficult times. And whether you're dealing with someone who has agoraphobia or some kind of another phobia or major depression, anxiety, bipolar disorder, whatever it is, maybe sometimes the illness is not even diagnosed. They just know what the symptoms are. And the doctors are all saying, yeah, it's legit. The person is unable to work because of X, Y, and Z. But we don't see it. Well, let me ask you, John, if you have a headache, are you going to see that on an X-ray? Maybe not.
Yeah.
Are you going to see it on an MRI? Maybe not. Yeah. It doesn't mean that if we can't see it, it doesn't exist. And yet insurance companies a lot of times treat it that way. So you have to take extra care of making sure that you document the treatments, and that's not you, that's going to be whoever you go to. If you go to your family doctor repeatedly, make sure that you express whatever is bothering you. If you have a psychologist, try not to miss appointments, because the insurance company is going to come back and count how many appointments you've missed. And do you have a good reason for missing them? Otherwise, they're going to say you're not trying to get better. Yeah. You're not mitigating. So you want to make sure that you don't give the insurance companies the ammunition to fire those rounds at you and use those to support their claim that you're not disabled. Because, I know, the doctors are out there know that the person is disabled, the net insurance companies are going to use whatever they can to deny that claim.
Let's grab another email again. help@inyourcorner.ca is the email address you want to use. Says Sonia says, my claims adjuster for my LTD has just threatened me, saying that she will do anything in her power to make sure that I am back at work in a few months, no matter what. Can they threaten someone like this?
They certainly do not have the right to do so.
They do, but
they do it. They do it, and you know, I have seen this time and time again. In some instances, I can tell you that I've seen it even documented. I've seen emails that adjusters have sent individuals, and those adjusters are just, as far as I'm concerned, not the brightest bunch. But in most instances, it will be oral. It will be by phone, and they will tell the person, you know, you have to go back to work. They'll use those words. You have to try to go back. You don't have to do anything. You don't. If your doctors are saying that you're not well enough to go back to work, and you know that you're not well enough, they cannot force you to go back to work. They will not go and come to your house with a gun and point at your head and say, you have to go back. What they will do, and I've seen them do over and over and over, is they'll say, we're going to cut you off payments if you don't do this. So here's how you fight back. It's really simple. Two things. Number one, you memorialize that conversation. Mm-hmm. As soon as you put down the phone, you email your adjuster and you say, here's the conversation we just had. Take emotion out of it. Make sure that it's very factual and fact-specific and as accurate as you can remember it. And say, here's what you told me. Here's the reason why I told you that I can't go back to work. I will provide you with a letter from my doctor or doctors explaining why I can't. Yeah. Leave it at that. Then go to your doctor or your doctors and get from them whatever reports they can give you, whatever letters they can give you that explain why you are not able to go back to work. The insurance company will be foolish to then cut you off, because if they do, not only can we hit them back hard and force them to pay you what you're owed, but we could potentially go after them for above and beyond that. We can go for what's called extra contractual damages, punitive damages to punish them.
Sure.
And courts have done that. Courts have done that in the past. They have nailed insurance companies to the wall. They've made insurance companies pay above what it is that the policy dictates, to slap them on the hand, to tell them you cannot do this. So this is not unprecedented. Do not back down. You have certain rights. Do not be bullied. They can't do whatever they want. The law applies to them just like it applies to you.
If you're a unionized employee and you're finding yourself that the union is unable or unwilling to help you fight the insurance company, we're going to tell you what to do and what steps to take next. That's after a short break. 1-855-821-5900 and help@inyourcorner.ca for email. Lots more coming up. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to In Your Corner, another resource outside of email, which is help@inyourcorner.ca. And of course, the phone number, 1-855-821-5900 is mydisabilityquestions.com. You can ask your questions there. Sivan or James, I'm pointing to James even though he's not here. It's kind of weird. Or a member of the team will answer those. If your question has not already been answered, which is a pretty high probability it has in depth, they will get back to you with the answers. Again, mydisabilityquestions.com. Danielle writes in, says, if I was denied LTD and am currently in the process of appeal, does my insurance company owe me the payments that I was denied? The appeal process has been almost 5 months now.
Yes, so the answer is yes.
Yep.
But the bad news, Danielle, is that if you're going through all these appeals, it's going to be a lot more than 5 months by the time that we start,
Wow. Okay.
the ball rolling here. stop with this appeal process. Well, you don't have to stop it. I mean, you can just let it go, but let us start a claim on your behalf now. And what people need to understand is that when we start a legal claim for long-term disability, we are asking for several things. And one of the things we're asking for is exactly what Danielle is asking about, which is that payments owed to the individual for that period of time from when they were first denied. Retroactive payments, or when they were cut off. Yep. And from that point up until the date of settlement. That's called retroactive pay. And sometimes that amount is taxable, sometimes it's not. It all depends on the nature of your policy and whether or not your payments were taxable. We can get to that at a different show. We're also asking for a certain amount for the future types of benefits. Remember, I mean, we're asking them to reinstate you or to put you on claim.
Right.
That's really what we're asking for. So it depends on what the insurance company ends up wanting to negotiate with us. And remember, even though we are the ones negotiating with the insurance company, you are in the driver's seat. You're the one that we inform. It's like a real estate transaction in a way, right? I mean, the real estate agent is not buying your house or the house for you. They're informing you of the choices, and then you make that final determination. So that's what we do here. So yes, Danielle, we go after retroactive pay, and we also go after future pay or a reinstatement, in addition to other types of damages like punitive damages.
Help@inyourcorner.ca, the email address. Robin writes in, says, my best friend is struggling with a few severe medical conditions. He's 51 and has been a teacher for over 25 years, quarter century. It's pretty good. He was denied long-term disability, and his union refuses to help him fight the insurance company. Can you guys get involved?
We can. With the majority of unionized employees, we can. What we do is we look at a collective agreement, and if the collective agreement does not talk about long-term disability in a very comprehensive way, then generally we can help the individual. And what I tell people, instead of going into the technicalities, is we help a ton of teachers. And there was one instance recently with Julie Austin that was featured by Global. There were several segments done with myself and James. And James actually ended up going after the insurance company. They ended up reinstating her. So we deal with a lot of teacher-type claims. Look, unions are not in the business of fighting long-term disability claims. Of course not. Okay? They can be very helpful to employees in certain circumstances, but not when it comes to LTD. That's not their expertise. And so even if you are a unionized employee, if you're experiencing a problem with your LTD insurer, maybe they denied your claim, maybe they cut you off, you should be calling us or emailing us. We can take a look at all your documentation and literally within minutes tell you if you have a case or not.
It's not generally in much detail in the collective bargaining agreement to have stuff about LTD. That's really why they need you, right? It's not their thing.
It's not their thing. It's not their thing. And we'll tell you if we can't help you. I mean, we'll advise you of that. But, you know, we've even had union individuals, people who work for unions, refer their own union members to us because they understand that we've been able to help other people in their union, whether it's teachers or sheet metal workers or any other types of unions. We've helped a variety of people who are unionized, unlike on the employment side.
I was just about to say that.
Where Lior will tell you they can't help you with your employer. With LTD insurers. We've even had situations where under the collective agreement we're not allowed to actually act on the person's behalf. But when we contact the insurance company, they prefer dealing with us as opposed to with the union. And because they got better results the employee got better results. So, even if you're unionized, you have an LTD issue, you give us a call or you email us. Won't cost you a thing to have a chat.
Got about a minute left, man. Take it home. What do you think?
So again, I think it's important to understand, and I think people need to understand, do not be afraid. Do not be frustrated. Do not feel powerless when you're dealing with an LTD insurer. I am telling you as somebody who used to work for insurance companies, it is a bluff. If you think you have a legitimate claim, your doctors are telling you you can't work. The insurance company is banking on you walking away. I know that I've been saying this over and over and over, and there are other lawyers, John, who say this over and over and over. We are saying this because it's true. Insurance companies don't want you to know that. As soon as you stand up for your rights, they come to the table ready to negotiate.
Lots on the show today. You want to reach out, there's a ton of ways to do so. MyDisabilityQuestions.com. We got to one of those today. Of course, a bunch of emails were read. That is simply help@inyourcorner.ca. Anytime James Sivan, member of the team, answer those, and we'll get back to you. And of course, 1-855-821-5900 is the phone number anytime as well. Thank you for joining us. We will catch you next time on In Your Corner.